Hello, everyone, and welcome to One Civil Law. And for today's case, we are dealing with the transgender rights of a one-year-old child. This is from the Eastern District of Washington State. This is the case of James Blaise versus Ross Hunter, the Secretary for Children in Washington State. So, some people wanted to essentially adopt their own great-granddaughter who was under 1 year old at the time. I think they were 4 months old at the time. And the state of Washington didn't want to let them because the great-grandparents didn't sufficiently recognize the transgender rights of their 4-month-old great-granddaughter. Let's get started with this. In September of 2019, Gail Blaise's granddaughter gave birth to HV. So their granddaughter gave birth to HV, which is now their great-granddaughter. So their great-granddaughter was born September of 2019. The child was removed for reasons that are unrelated to this. So in January of the subsequent year, so that's September, October, November, December, January, 4 months later, 4 months after their great-granddaughter was born, the Blaises applied for a foster care license to foster care their own great-granddaughter who had been removed from their mother because of reasons unrelated to this. So these great-grandparents over here want to take care of their great-grandchild offspring because it's been removed from their parents. And at 4 months old, this child, they'd like to say, I'd like to take care of my own great-granddaughter, please. The state would like to ask some questions first. What questions would the state like to ask? I'm so glad you asked. Though only an infant, which I don't even know if that's the proper term for a 4-month-old infant, but whatever. Though only 4 months old, Child Services over here decided to ask hypothetical questions about this 4 months old possible future sexual orientation and gender identity. The state would like to ask the great-grandparents, how do you feel about the sexual orientation and gender identity of your 4-month-old great-granddaughter? These questions included these following specific examples. How would you react if your great-granddaughter, the 4-month-old, was a lesbian? How would you allow your great-granddaughter, the 4-month-old, to have a girl spend the night at home as part of being a romantic partner? If at 15 years old, your great-granddaughter, the 4-month-old, were to undergo hormone therapy to change their sexual appearance, would we support that decision and transport them for treatment? If, as a teenager, your 4-month-old great-granddaughter wanted to dress like a boy and be called by a boy's name, would we accept that decision and allow them to act in their manner? These are the pertinent questions the government would like to ask about how would you treat your 4-month-old great-granddaughter if they're gay? To which my answer would be like, what are you even talking about? But the state of Washington thought these questions were super important to ask the great-grandparents. Okay. The Blaises informed Child Services that their faith obligates them to love and support all people. They conveyed that this rule especially applies to children who may feel isolated or uncomfortable. As to specific questions on possible hormone therapy, which again, this is possible hormone therapy of a 4-month-old, they responded that although they could not support these treatments based on sincerely held religious convictions, they would nevertheless be loving and supportive of their 4-month-old great-granddaughter. They also indicated that in the unlikely event their great-granddaughter may suffer gender dysphoria, which, based on statistics, is pretty unlikely as a teenager, which, is a little bit into the future at this point, we would provide them with loving, medical, and therapeutically appropriate care that is consistent with both accepted medical principles and our beliefs as Christians. These answers apparently alarmed the government. These answers apparently alarmed the government. These were not the right answers. So the government would like to not let them be their foster parents because of wrongthink. Yeah. How long exactly is it? How long exactly is it before the state of Washington starts asking these questions to natural parents of their own children. Seriously, how long is it before Child Services shows up at some door somewhere of some parent of a 4-month-old as their own kid and says, how do you feel about gay rights? And then threatens to take away their kid. And if you think that's ridiculous, well, I don't know what to tell you. I'm reading the text on the page. We're not a lot of steps removed from that as far as it goes. The government informed these great-grandparents that they would deny the application because their answers conflicted with policy to support LGBTQ children. For example, if they were not willing to support hormone therapy for transitioning, even if it was medically necessary or recommended, which incidentally, I'd like to point out, those are two vastly different things. I don't like this conflation. I would like to humbly suggest there is a pretty stark difference between medically necessary and recommended. You can't just say those two things like they're the same thing. You can't just say, well, what if it's medically necessary or recommended like it's the same thing? You know, it's just, no. Or counseling that was not consistent with their beliefs. To support boys wearing girls' clothes or vice versa, which, you know, I'd like to note implicitly says there is such a thing as boys' clothes and as girls' clothes, right? You can't support boys wearing girls' clothes or girls wearing boys' clothes unless there is such a thing. You can't support it unless, first of all, there's such a thing as boys and girls. And you can't support it unless there's such a thing as girls' clothes and boys' clothes. So are girls and boys a thing that exists? And are boys' clothes and girls' clothes a thing that exists? Because you can't support boys wearing girls' clothes or girls wearing boy clothes unless boys and girls exist and are distinct, and girl clothes and boy clothes exist and are distinct. So do they exist and are they distinct? And if so, why are we having this conversation? To allow this 4-month-old child or other foster children to date in the future, or to call a foster child by their preferred name if it was different from their given name. So if in the future this 4-month-old wants to be called a different name, will you call them a different name and support their decision to wear clothing of the opposite sex, which implies there is such a thing as the opposite sex and also implies those are distinct things? Because you can't have girl clothes and boy clothes unless those are separate categories. They have to be distinct. Otherwise, the label doesn't make any sense. To have a label, to be able to label two different things, they have to be distinct so you know which is which. They have to be different. So that means there is such a thing as girl clothes, and there is such a thing as boy clothes, and there is such a thing as girls, and there is such a thing as boys, and those are distinct things. Which is what these people's point is. And what if they want to call themselves a different name? You're 4-month-old. Okay. After advising their supervisor of this horror show, they decide, oh my God, this is where it really goes to hell, just in case you're wondering. This is full-bore re-education camp, kids. We're full-bore re-education. So after advising their supervisor, they decided to send these great-grandparents re-education materials and statistics about children. We're re-educating you because you are of your wrong think. The email invited them to review these materials so they could make a more informed decision about supporting this child in foster care. After reading these materials, the Blases reiterated their sincerely held religious belief and repeated their pledge to offering a loving and supportive home to any foster child in their care, including their own biological great-grandchild offspring. Still, they held steadfast to their conviction that they would not support hormone treatment for a child wishing to transition. The re-education did not work. Then the government decided to ask some new questions, but similar. So here are some new questions we'd like to ask you about the 4-month-old. So here's some new questions. If this 4-month-old great-grandchild had a lesbian girlfriend, would you be willing to have her visit your home and possibly travel with you? Would you find it acceptable if this 4-month-old great-grandchild dressed like a boy? My question here is, what is a boy? I'd love to hear the government answer that question. That would be hilarious. What would you find acceptable if this child dressed like a boy? My question is, what is a boy? I'd love to hear you answer that question. That should be fun. Would we find it acceptable if the 4-month-old great-grandchild wanted to be called by a boy's name? What is a boy's name? Are you saying that there's such things as a boy's name? There are names that belong to boys and are not girls' names? What is a boy's name? Please answer this question. If at age 14, a doctor ordered your 4-month-old great-grandchild to undergo hormone therapy to change her sexual appearance, would you comply with the order? I'd like to take note here that a doctor can't really order anyone to do anything. What do you mean by doctor ordered to undergo therapy? Like the doctor is requiring it. Last time I checked, a doctor can't order me to do anything. No, that's not how doctors work. No. If at age 14, your 4-month-old great-grandchild said that he would not agree with having hormone therapy and she would leave your home and run away, how would you respond to this threat of them running away of the 4-month-old? I don't even begin to know what to say. Several days later, Child Services over here asked the great-grandparents to meet with them again because the answers were unacceptable, this time via video conference, with the department's LGBTQ lead, Carissa Stone. They agreed to have the call. During the call, they discussed the policy 6900. It's policy 6900, which I have to say in this instance is the exact opposite of nice. I have to wonder here. I have to wonder. What are the odds? What are the odds that this is policy 6900 by random chance? What are the odds that this is policy 6900 by random chance? What do you guys think? What do you think are the odds that it just so happened to be the 6900th policy of the administration? Or what do you think that they picked it because of associations between the number 69 and certain prurient activities? You think this was a random number just so happened to be, or do you think this was picked? I'm going with option number 2 on this one personally. Policy 6900, which is the department's policy of how the staff will make sure children who identify as LGBTQ have safe and affirming care. Because the Blaseses had remained faithful to their beliefs, and they're horrible, horrible people for that, the government advised them that they had reached an impasse. No, not so much. You can't be a foster child to your own great-granddaughter because of the wrong thing, because it violates policy 6900. The great-grandparents would like the court to do something about this, alleging these restrictions violate their rights because it encourages individualized assessment that target people for special disabilities. People who are religious are specially disabled. It operates in a non-neutral way to religion. It compels speech because it forces us to agree with the government, flouts substantive due process, violates hybrid rights, and imposes unconstitutional conditions. I feel somewhat compelled to point out at this point that various conservative commentators have over the years been suggesting that these guidelines would eventually be used to separate children from their parents. And I'd like to take note that some of the brethren on the left have said such a thing would never occur. How many steps are we away from that now, man? We literally have the government trying to keep biological great-grandchildren from their own great-grandchildren because they're unfit because they don't believe in the LGBT cause. How many steps are we away from this being applied to biological parents at this point? Not that many steps, man. All the people on the left who said this would never come, I feel like we're there at this point. I'd say I told you so, but I'm not getting any satisfaction in it. Let's discuss the First Amendment and how it applies to this, at least for today. The Free Exercise Clause of the Constitution, which continues to be a thing that continues to exist, says Congress shall make no law that prohibits the free exercise of religion. Free exercise of religion means first and foremost the right to believe and profess whatever religious doctrine you desire. You have a right to believe anything you want. You have a right to profess those beliefs. Not all burdens on religion are unconstitutional, because any statement that's sweeping and saying all would be always a problem, right? Because very rarely is something always true. The state may justify limitation by showing it's essential to accomplish an overriding governmental interest, which is basically strict scrutiny, right? The right of free exercise of religion does not relieve a person from complying with a valid neutral law of general applicability, citing Smith, and could also have cited Lemon for basically this proposition too. The Blasey's argue that these regulations and policies operate in a non-neutral manner that suppress religious belief. The department counters its regulations operate neutrally because they apply equally to all foster care recipients. We're not discriminating on the basis of religion. We apply our secular litmus test evenly to everyone. They either agree with the one true faith, which is completely secular in its nature and evenly applied, or they don't get government benefits. A law is not neutral if the object of the law is to infringe upon or restrict practices because of a religious motivation. No. The Washington Administrative Code outlines the personal requirements for foster parents. For example, foster parents must follow all state and federal laws regarding non-discrimination while providing services to children in their care, and must treat foster children in their care with dignity and respect regardless of race, ethnicity, culture, sexual orientation, and gender identity. I'd like to take special note here that this list is excluding something that you normally see in this list. Let's see if you can spot the thing that is normally in this list that is conspicuously absent from the list. I'll read it again to give you time. The foster parents must treat their foster children in their care with dignity and respect regardless of race, ethnicity, culture, sexual orientation, and gender identity. What thing is normally in that list that is conspicuously absent from that list? If you said it doesn't say regardless of religion, ding, 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 you win the prize. Policy 5100 provides that children administration is prohibited from denying any person the opportunity to be a foster or adoptive parent on the following basis: race, creed, color, national origin, gender, honorably discharged veteran or military status, sexual orientation, or the presence of any sensory, mental, or physical disability, or the use of a trained dog, guide, or service animal. What thing is conspicuously absent from this list that is normally in this list? I'll give you a minute to determine. If you can determine what thing that is normally in this list is conspicuously absent from this list, I'll read it again to give you a moment to decide. Children's Administration cannot deny any person the ability to become a foster parent on the following criteria: race, creed, color, national origin, gender, honorably discharged veteran or military status, sexual orientation, or the presence of any sensory, mental, or physical disability, or the use of a trained dog, guide, or service animal. What thing is normally in this list that is conspicuously absent from this list? If you said it doesn't prevent them from denying any person the ability to become a foster parent on the basis of religion, ding, 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 you win the prize. The Washington Administrative Code governs licensing requirements for children's foster homes. The regulations here do not reasonably accommodate religious belief or conduct of foster care provisions. For example, by requiring a foster parent to connect a child with resources that meet a child's needs regarding race, religion, culture, sexual orientation, and gender identity. So the foster parents have a duty. The foster parents have a duty to connect with their child on the basis of religion. The child's religion. Not conspicuously absent from this list, the foster parents have a duty to connect with their child's needs regarding the child's religion. Not absent from this list, the child's religion is super, super important. The foster parent's religion, much less so. The department ostensibly did not intend to restrict or deny any particular religious belief or conduct because of religious motivations. That's a very charitable conclusion, court. I have to say that's a very charitable conclusion to say the department did not intend to infringe. I'm gonna have to respectfully disagree. That's a very, very charitable conclusion with these facts. Policy 6900 applies to licensing division staff, including those who conduct home studies for foster care licensing applications and placement requests, and provides that children or youth who identify as LGBTQ, including the 4-month-old, will not be subject to discrimination or harassment on the basis of actual or perceived sex, sexual orientation, gender identity, or gender expression. I don't even know what some of these terms mean in the context of a 4-month-old. Closer inspection of the regulations and policies at issues reveals that, in practice, they work to burden potential caregivers with sincere religious beliefs and almost no others. You don't say. The department's interpretation of regulations and policy also favor certain secular viewpoints over certain religious viewpoints. You don't say. For example, the department favors religious and non-religious applicants who have neutral or pro-LGBT views over religious and non-religious applicants who have non-neutral or anti-views. Here, the approval of the Blazes' application hinged on their stance of LGBTQ rights and whether they intend to remain faithful to their religion. Yet, to be eligible for foster care, the department requires the Blazes to divorce themselves from their religious beliefs. The Washington Code declares the right to be free from discrimination because of creed. The policy likewise prohibits the department from denying any person the opportunity to become a foster parent because of creed. Department regulations and policies may appear to be neutral, but in practice, they gerrymander to create an unequal effect. The court concludes department regulations and policies operate as a religious gerrymander and thus are not neutral as applied to these. You don't say. Department regulations and policy force the Blazes into a dilemma: adhere to their relations and give up the benefit of foster care of their own great-granddaughter, or forsake their religion and get a foster care license. Because such regulations and policy involve individual assessments imposing substantial burdens, the court concludes strict scrutiny applies to protect free speech rights, free exercise rights from government encroachment. The regulations and policies here do not generally apply because the department selectively imposes burdens on only certain religious beliefs at odds with its policy to support LGBT youth. The department claims the Blazes have not shown irreparable harm because they have no right to a foster care license and have failed to exhaust their administrative remedies. The court disagrees. Okay, let's take one step of note here, that the government is arguing that the Blazes, the great grandparents, have no irreparable harm in being denied the right to foster their own great grandchild. There's no irreparable harm from the great-grandparents being refused the right to denied the right to foster their own great-grandchild. That is not an irreparable harm, says the government. Just gonna let that sit there for a minute. The court disagrees. Yeah. First, even if they have no right to a foster care license for their own great-granddaughter, the Free Exercise Clause protects against laws that penalize religious activity by denying a person an equal share of the rights enjoyed by other citizens. Other Washingtonians may apply for a privilege and benefit of becoming a foster parent. Penalizing the Blazes for their religious belief violates the Free Exercise Clause by denying them an otherwise available privilege or benefit. The privilege of being parents to their own great-granddaughter, the 4-month-old. This court does not enjoin the department from taking LGBTQ considerations into account when reviewing licenses, but a foster care's applicant's answers to these hypotheticals cannot serve as the sole determining factor when an applicant expresses sincerely held religious beliefs. Which means, in practice, I'm sure we can all divine exactly what that means in practice, and if you can't design what that means in practice, you're not thinking very hard. What that means is the government is now going to try to conceal its true motives. They will find other reasons they are unfit parents, no matter how tenuous. We're not discriminating because of religion. We're discriminating because, I don't know, they're old, or they haven't been parents in like 60 years because it's their great-grandchild, or Its decision must be on something more. I'm sure you can come up with a pretext. If the only factor weighing against an otherwise qualified applicant has to do with religious beliefs, the department may not discriminate against foster care based on this creed. The department must make a reasonable accommodation for religion. I'm feeling that religious accommodation just coming right down the pipe, man. I feel like the department over here is going to take this to heart, and they're just going to reasonably accommodate all the religion. I definitely see that like a thing that's happening, especially in the cases like this one where the potential placement involves a biological family member because it's their own great-grandchild. Thus, that brings us to the end of the case of Blazes versus Hunter, the Secretary of Children in the great state of Washington. And the conservatives who have been saying, you know, this may interfere with family relationships, and we're laughed off. Well, you're kind of there. The great state of Washington feels like a great-grandparent should not be a foster to their own great-grandchild because they're inadequate to serve, because the 4-month-old great-grandchild, what if they have a lesbian partner? Yeah. So this is definitely a thing that's happening, and definitely a thing that's going, and we're about a half step removed, if that, from the government knocking on doors of parents and saying, hey, what about your child? And if you think that's ridiculous, I don't think you were fully paying attention to this case. We're one step removed from saying, if that, we're half a step. We're about a quarter step removed from the government saying you're unfit to be a parent for your own child because you don't believe in LGBT rights. If you can't see that coming, I don't know what to tell you. You're already pretty much there. And 4-month-olds have transgender rights too. We're about one step away. We're about one step away from the government requiring you to answer a survey before you take your child home from the hospital, which is incidentally what this would be, right? So before you can take your own child home from the hospital, you have to answer a survey. You have to answer some questions. And then, hey, you answered them wrong, and that 1-month-old man, we got to intervene. For the moment, though, that brings us to the end of this complete horror show of a case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.